All right, welcome back. It's been quite a day in courts today. Just all over the place. Well, I should say Michigan courts. And there there was there was quite the sovereign citizen hearing in Judge Washington's court, but that's he's a rambler, and only I'm allowed to ramble on this channel. But that being said, I might cover that video later, but like I said, that kind of sovereign citizen bugs me. I just ugh. So instead, we're going to Judge Simpson's court, and this video, once again, thanks to Old Squishy Gardner. Go subscribe to his page, give him a view, thumbs up, all that jazz. And hey, do the same for me. I always forget and say it at the end of the video, but do all the YouTubey stuff for me too. Like, share, subscribe, bribe your friends to do the same. And so for those of you who are new, I'm Joe. I'm an attorney licensed in the state of Utah. This hearing is in the state of Michigan, and it's Judge Simpson. I mentioned yesterday how I really liked Judge Washington. She's the kind of judge I like to appear in front of. Judge Simpson, not as much. I think he has a huge heart. He really cares. And you see a hearing like this and you understand why he gets his dander up sometimes. And so our hero, maybe my anti-hero, is top second from right, the one Theophilus Smith. He's the one in the turtle suit with that expression at the moment. And yeah, so Old Squishy Gardner's video is titled Argue Bond Against Both Your Attorneys and the Judge's Advice. Get a 200,000 increase. So that's a teaser, but let's jump into it.
Court calls the case, People versus Theophilus Smith.
Nicole Hughes on behalf of the people.
Edward Drukas on behalf of Theophilus Smith.
Mr. Smith, can you state your name, please?
Theophilus Smith. May I go in the breakout room with my attorney, Your Honor?
No.
Hate to pause it already, but frequent viewers of Judge Simpson know he does not do breakout rooms. You talk to your attorney before court. Or you get an adjournment and come back later. He doesn't do breakout rooms because they disrupt the flow of his court. Attorney Drukas is a public defender or appointed counsel, whatever. He's not hired by Theophilus Smith, as we'll find out later. So he might have the next 5 cases in front of Judge Simpson. If he gets a breakout room, hey, you've got to wait on those next 5 cases. And like I said, it disrupts Judge Simpson's flow.
Because I haven't.
Pardon?
Because I wanted to change some things I wanted to do. Me and him talked briefly, but I didn't get down to the A's and B's.
You didn't get down to what?
I wasn't able to tell my attorney exactly what I wanted him to do for me today.
So, fun story. You don't get to tell your attorney what you want to do today beyond, I want to plead guilty, I want to plead not guilty. You get to decide whether or not the case resolves. Your attorney gets to decide how to get there. Attorney Drukas is a fine attorney. He's an excellent attorney, even. He's got what he needs. If he needed more, he would have asked more. As we'll find out, maybe less is more in this situation, but no spoilers.
Mr. Drukas,
Thank you, Your Honor. Actually, I did spend about 50 minutes with him here this morning. I did get the discovery. There are some video that I did start to go over with him. We also discussed some potential other video that may still be outstanding. And again, I was appointed yesterday. I'm looking to get an adjournment today, so I can fully go over the discovery with him and make a determination on what to do.
Okay, so there you go. Like I said, I wasn't sure if he was appointed or public defender. He's appointed. What that means is the public defender's office was probably conflicted out, unable to represent him. So they got a private attorney and are paying him to be his public defender, basically. And I've watched it once already, so this is my second viewing, and I didn't quite catch it either time. I don't know if he said he spent 15 or 50 minutes with Mr. Smith. Either way, 15 minutes with a public defender, frankly, is more than most people get before a hearing like this. And as Attorney Drukas said, he received some discovery today, but there may be more videos forthcoming. And for Mr. Smith, that's not a good thing. More evidence from the prosecution is usually not good. You want them to have as little evidence as possible. Unless, of course, it's exculpatory or Brady material or whatever. But
probable cause conference in this matter,
What about-
November 9th,
Did you
2023,
address bond?
9 a.m. Excuse me?
Can my attorney address my bond?
Well, he knows how to do that, but yeah, go ahead, Mr. Drukas.
Mr. Smith, I had gone over that with you. With regard to right now, we're not going to be addressing bond.
once again, that's the attorney's prerogative. He understands the case. He understands that at this point, you're unlikely to effectively be able to argue. Now, Judge Simpson didn't set the bond. We'll find out later. It was a magistrate who set it. And spoiler alert, it's $50,000. I'm unsure if it's $50,000 cash or $50,000 cash or surety, so 10%. Mr. Smith thinks it is, but it sounds like maybe it wasn't. But if Mr. Drukas thought he had a good argument, he would have brought it up. But yeah.
But I didn't want to, that's why I wanted to go into the breakout room so we could be on the same page.
I know.
Your
You
Honor,
don't need to go over this on the record, Mr. Smith.
Mr. Drukas, for the record, should defense counsel address bond, I will be asking the court to increase the defendant's bond. I understand why Mr. Drukas is making the decision he's making.
Okay.
So, prosecutor, before it's even on the, before it's addressed, prosecutor puts it on the record. Don't even think about it, because if you do, I'm asking for an increase now that it's in front of the judge. Because I've got more information. It's bad news.
I understand. When is my next court day?
So are we done with the bond thing?
No.
He ain't even addressed it.
Yes, Your Honor. I believe you had said November 9th.
Mr. Durkin,
Yes, Your Honor.
do you want to address bond? He wants to address bond.
No, Your Honor. I'm asking for that
Is,
XPC on November 9th.
Mr. Smith, the risk is if I address bond, I'm going to address all bond. I'm going to leave it where it is right now, but the people have made it clear that they're going to be asking for an increase.
So when he says, if I address bond, I'm going to address all bond, it means, hey, you don't get to make your argument, and that's that. It's, if I let you make your argument, the prosecutor gets to make her argument. And that might not go so well for you, is the inference there.
Your counsel is making a strategic decision not to address bond at this time. But if you wish bond be addressed, then
No, I did not want to postpone my preliminary. I wanted my preliminary to be, I didn't want to post no more probable cause. I want to move towards the preliminary. I don't want to have another probable cause conference.
have you looked
That's why
over
me and
all
my
the-
attorney not even on the same page. Me and my attorney.
Mr. Smith,
don't do
Mr.
this.
Smith, did you listen to what your attorney said? There's video he still has to go through with you.
So basically, Mr. Smith wants Attorney Drukas to go, basically go in blind for a probable cause hearing when he doesn't have all the video. Like I said, more video probably isn't better video for the defense. It probably bolsters the prosecutor's position. But with a little spoiler here, he beat the hell out of a woman. And what Attorney Drukas wants to establish is he wants video from before to see if she provoked him. So that could be a mitigating factor. It could show, hey, maybe it was even self-defense. Maybe there is no probable cause. It's a small chance, but hey, it's better than her coming in with her jaw wired shut. Yeah, he beat the shit out of me. That just going in unprepared and with that as your only evidence, that's really, really bad for the defense.
But
So you want to have your preliminary examination before that happens? Because
Yes.
if I said it, I'm going to instruct the judge that not to adjourn it because you want to look at the video now.
To be
And that's Judge Simpson doesn't know it yet, but he's going to be the judge assigned to this case. But he doesn't want the defense playing games, because what'll happen is, you know, he sees this all the time. So he doesn't want Mr. Smith to say, well, I want my probable cause conference now. And then as soon as it comes up, well, I haven't seen the video yet. I need it postponed. Well, you just wasted a slot on the court calendar. Those are valuable. They're hard to come by. So come prepared and come once. And so Judge Simpson is saying, hey, whatever judge gets this case, you know, not knowing yet that it's going to be him, they need to know, hey, they were in the rush, so they get to live with the consequences. Now, would the future judge be bound by Judge Simpson? No. Would it be persuasive? Yes.
be clear for the record, the videos that we have turned over to defense counsel include the defendant brutally assaulting a victim. She was on the ground. He kicked her in the face repeatedly until she was left with what looked like a broken jaw to the police. She could not open her mouth and she could not speak. and she was rushed to the hospital. Defense counsel has requested an adjournment and requested that I look into whether there are additional videos leading up to the assault to help Mr. Smith explain to the court perhaps what happened leading up to that. I am more than happy to continue to a preliminary exam with the only evidence available being the brutal assault that this man committed on that woman. So, Your Honor, if we want to go to an exam, let's go, but I will not be getting those videos turned over before that exam date.
Well said by the prosecutor Hughes. And she's, well, first off, huge mistake by Mr. Smith giving her an opportunity to put that on the record. I mean, it's gonna come out eventually at the probable cause conference, but if the judge is going to be considering bond in any way, you don't want her to have an opportunity to say that. Your best bet is just take the gift that is $50,000 bond. Not that he's getting out on that anyway, but you know.
Hey, what do you folks
I go
want
in
to
the
do?
breakout room with my attorney, Your Honor?
No, I already said no.
So
you wanted set.
Raheem Bragg gets it. The next to Theophilus Smith, he's shaking his head, saying, "Nah, man, you're not getting it." But Raheem Bragg does.
You already spoke to your attorney. Your attorney had a very clear picture as to what he wanted to do. You come here this morning, I think, changing things. And I just want, if you want it set for an exam, I'll give you an exam. I'm assuming that setting it for an exam, Mr. Drukas, that would be over your advice to him at this point.
That is correct, Your Honor. Mr. Smith, let's proceed to November 9th and we'll continue to negotiate with the prosecutor.
no, I want to say it to the exam.
Okay, well, that's against my advice, Your Honor.
Hughes,
We can have an exam
Ms.
date.
Hughes, ready to go to an exam this Tuesday?
We will do everything we can to get the victim there, and hopefully,
All right.
given her injuries, she's able to speak at that point.
And here, like I said, prosecutor or attorney Drukas, he needs to tell his client who's boss, because the client doesn't decide when court happens, when the exam happens, whether to ask for an adjournment or anything like that. Mr. Drukas is not doing Mr. Smith any favors. Now, he's a fine attorney, and you can tell your client, hey, if you want to make your bed, you've got to lie in it. But sometimes you need, and as I've said, one of the problems with Zoom court is you're not standing next to your client to elbow him in the ribs and say, shut the fuck up. Which you don't do in court because that's naughty. And I see Chief Public Defender Lauren Brown at the bottom of the screen. I wonder if he would have been able to get through to Mr. Smith. I doubt it, because we'll find out soon that he's mentally ill. Not Lauren Brown, but Mr. Smith.
All right. Well, we'll figure it out at that
Now, can
point.
we address
But we'll start his exam.
Can we address?
We'll start his exam October 31st,
Can we address
2023, 9 a.m. That's before me.
On Halloween.
All right. Mr. Drukas, I
Yes, Your
realize
Honor.
your client's pushing you over your advice. Do you want me to address bond?
No, Your Honor.
Mr. Smith, you want me to address bond
Please, Your Honor.
over your attorney's advice?
Yes.
Okay, go ahead. Tell me what you want me to know.
And I like how Judge Simpson did that. Mr. Drukas, do you want to address bond? No. Mr. Smith, over your attorney's objection, do you want to address bond? Because what's going to happen is Mr. Smith is going to go after Mr. Drukas. He's going to put in a bar complaint and say, Mr. Drukas got my bond increased by $200,000. But it's on the record that it was against Attorney Drukas's advice, that he vociferously objected. He said no multiple times. I mean, there are times where, as an attorney, if your client insists on doing something extremely stupid, sometimes you just have to write them a letter. Well, I mean, you explain it to them first, but you write them a letter and you send it registered mail through the U.S. Post Office. You don't do it by email. You send it with a return receipt and fully documented, and email, do both, and saying, let's say that they're going to testify in their own trial, and you tell them, this would be the absolute stupidest thing you can do. You have a Fifth Amendment right. You should use it. You should shut the fuck up. And they say, no, I think I can pull one over on the prosecutor. They're not going to be able to figure me out. And you tell them, if you testify, they'll get to cross-examine you. It will not go well for you. And they still insist. You send them a letter, Mr. Smith, the Constitution gives you the Fifth Amendment right to remain silent. I suggest you use it. You also have the constitutional right to testify at your trial. I believe that would be a very bad idea, and suggest you invoke your Fifth Amendment right and don't testify. The prosecution can't even comment on you not testifying. The jury can't hold it against you for not testifying. But if you insist on testifying against my advice, you may. And that way, when they're convicted and they go to the bar with a bar complaint or sue you for malpractice or whatever, you go forward with that letter and the the return receipt and the email, and say, I told them not to. This was their choice. It's one of the few things they get to do, whether I tell them to or not. So I like that Judge Simpson got it on the record, because that's even better than registered mail. It's on the record. It's a court record. So,
Your Honor, my name is Theophilus Smith. I'm paranoid schizophrenic type 1, 2, and 3, and bipolar type 1 and 2. I had a rough breaking up, Your Honor.
So I'm a lawyer, not a psychiatrist or psychologist or anything. So for those of you who are, I'm curious. He says he's paranoid schizophrenic type 1, 2, and 3, and bipolar type 1 and 2. Is that possible? Like, I realize you can be paranoid schizophrenic and bipolar, but like, schizophrenic type 1, 2, and 3, are those mutually exclusive, or can you be all three? Serious question. I don't know. If you do know, put it in the comments.
I knew I should have called the law. I should have called the police when he was making all them.
I'm going to stop you right there, Mr. Smith. I don't want to go into the facts of this case.
He needs to take his attorney's advice and shut the fuck up. He's talking about the details of the case. This is going to be used against him. For those of you who wonder why I'm being a little more vulgar than usual, I mentioned a few videos ago that I'm going to make a competing alternative to Delete Law's Fifth Amendment card. Mine's going to be the shut the fuck up card, and I need to put together some shorts, basically, of that. So put a timestamp in there. Remind me to make a short out of that. But
no, I just let me talk, Jukas. Please let me talk. It's between me and the judge.
Well, you can't talk about the facts of the case.
oh yeah,
Your Honor.
Mr. Smith,
Yes.
just because you're going over the advice of counsel, I'm just going to advise you that anything you say can be used against you. You understand that?
it can and will be used against you. Can and will. And not only that, it cannot be used to help you in any way. Because here's the thing to remember. The rules of hearsay, there's an exception for statements by a party opponent. Mr. Smith is Prosecutor Hughes' party opponent. So anything he says, she can and will use against him. Attorney Drukas, unless there's some other hearsay exception, he's not, Mr. Smith isn't his own party opponent. So he can't get anything he says that's helpful in front of the court. So when they say anything you say can and will be used against you, that is what they mean.
Yes, Your Honor.
Okay. I've given you your warning and admonition. Go ahead.
Okay, Your Honor. Well, pertaining to the case.
And I'm going to stop you right there again, Mr. Smith. I'd prefer that you not speak about this case.
But I'm asking you to address bond, and you're not doing nothing I want you to do. So let me do what I have to do for myself. This is for me, not for you.
I know. And we talked about this. This is about
I know,
you.
but guess what? You not listening to nothing I'm saying. I would rather have layman's represent me. Layman's. Because you're not doing nothing I said. And me and you did, we wouldn't even want to.
Maybe it's because, now hear me out on this. Maybe it's because you are a paranoid, schizophrenic, violent jailbird. And Attorney Drukas is an attorney, and he knows his job. So when you say, you're not doing anything I want you to do, maybe it's because you want him to do the wrong things. Think about that.
The same page. We weren't even on the same page before the meeting ended earlier. So just let me talk without you objecting to your own client.
You're not on the same page because you're not in the same book. You're not in the same library. I mean, you're Random House. He's Penguin.
Can you let me?
All right.
Mr. Bragg
Mr.
loves
Smith,
this.
you seem to know better. You go ahead.
Your Honor, the defendant made several death threats to me. Not the defendant, the accuser. I don't know how to, the accuser.
So maybe, now hear me out on this. Maybe do what your attorney says and first, shut the fuck up. But second, maybe you should get an adjournment and not rush to the probable cause conference so that you can find out, hey, maybe the victim did make death threats right before you beat the shit out of her. So you're saying, hey, I was provoked. You're not going to have video showing any provocation before the rushed probable cause conference. You might if you listen to your attorney. Listen to your attorney.
Knocked on my apartment door.
And again, Mr. Smith, I'm going to reiterate that you should not be speaking about the facts of this case.
Okay, I'm not going to speak about the facts of the case.
Okay, thank you.
Your Honor, if you could please give me a personal reconduct bond. Your Honor, I'm not a flight risk. I'm going to be in court on Tuesday. If you can lower my bond or give me a PR, Your Honor, I won't speak.
A PR bond. Now, are you sure this guy's not a comedian? He wants a PR bond. He's got a $50,000 bond set by the magistrate, and he wants it lowered to 0 because he's not a flight risk. Well, the thing is, and we need bail reform in this country. I've said it before, I'll say it again. We need bail reform in this country. Non-violent first-time criminals shouldn't be languishing in jail before they've been convicted. But part of the calculus of setting bond isn't just whether or not you're a flight risk. It's, are you a danger to the community? He kicked in a woman's face. He is the definition of danger to the community. So, like, if we abolish cash bond and you either are denied and you sit in jail until your trial, or you're released for free until trial, this guy sits in jail.
Speak about no more of the facts of the case until Tuesday. I'm going to respect Edward Drukes on that point, that I won't speak on the case. But if you could just give me a PR bond or lower my bond, because my family is not wealthy, Your Honor. We are not wealthy, and I can't afford $50,000, no 10%. Your Honor, if you can please just give me a chance to give me a real lawyer.
So that just, frankly, that's offensive. That's highly offensive. And I'm glad that Lauren Brown isn't on the call anymore at the moment. At least he's not on video. Because I want to get me a real lawyer. I get so sick and tired of the, I want a real lawyer, not a public defender. Guess what? Your public defender went to law school. They passed the bar. They are a real lawyer. And there's a very good chance that they are the best criminal defense attorney in your area. Do you know how hard it is to get a public defender job in a big city? Real hard. Here in Salt Lake County, the LDA, those are some of the most sought after legal jobs. They are hard to get. And I mean, of my classmates that are public defenders, you bet your ass I'd use any one of them if I needed them. They may not be able to spend the time with me that a private defense attorney would, but at the same time, they're in front of the same judge every single day. They have rapport. They have rapport with the prosecutor they work with every single day. So even spending a smaller amount of time with you, they're going to get you at least as good a deal as your private attorney will. At least. And they're trying cases all the time. So frankly, they might be the best trial attorneys there are. Because just by virtue of private defense attorneys taking fewer cases and spending more time on them, they're not trying cases every day. They might try 10 cases a year, and that's if they are, you know, extremely busy and not taking cases that settle, but taking cases they know are going to trial. We're talking, for those of you who are fans of Bruce Rivers, CLR, you know, he's got 1 million subs, so you're more likely to be a sub to him than me. But, you know, in his opening, he says, you know, I'm a board certified criminal defense trial attorney, meaning I take cases to trial. The public defenders probably take more cases to trial than he does. And that's not a slight against Bruce Rivers. It's just your public defenders are probably the best attorney, you know. But that being said, Mr. Drukas isn't a public defender. He's appointed counsel. So, you know, with this case, if you went out to hire him, because as appointed counsel, he probably takes a couple appointments, you know, conflict cases. But for this, you know, I'm guessing it's aggravated assault. Michigan has weird rules, but here in Utah, this would be at least a 3rd-degree felony, if not 2nd-degree felony, aggravated assault, maybe even attempted murder. So you're looking $10,000 to hire Mr. Drukas to defend you on this, and that's not including trial. But you want to get yourself a real attorney. Is this like Pinocchio? One day I want to be a real boy. You've got yourself a real attorney. You've got yourself a really good attorney. And you're not paying $10,000 for that real attorney. Your real attorney isn't making $10,000 off of you. He's probably getting paid a couple hundred, maybe 1,000. Because you don't get paid a lot, even as appointed counsel or as a public defender. And that sucks. But you've got a really good attorney. So don't go insulting him on the record by, I want to get me a real attorney. I can't afford no $50,000 bond, 10%. I can't afford $5,000 to get out of jail, but I'm going to hire a real attorney that's going to cost me a whole hell of a lot more than that. It really gets me steamed, this crapping on public defenders.
Give me a lawyer. Give
A
me
real lawyer?
no, no, a lawyer. No, I don't mean. I'm not taking nothing away from Drukas. I'm not taking nothing away from Drukas, Your Honor. I just want to check.
Oh, okay.
I just want
Attorney
to be free, Your
Stuteville
Honor.
gets
I
it.
feel like I'm not even guilty of this. My grandfather got inside of me.
My grandfather got inside of me. Like, is that one of the voices he hears as a paranoid schizophrenic? But Judge Simpson gets it. You know, he caught the real attorney. He's about to say, hey, Mr. Drukas is a really good attorney.
My grandfather was talking to me. My grandfather.
Ms. Hughes, response to the motion to reduce bond.
Thank you, Your Honor.
And Mr. Smith, before you go, Ms. Hughes, Mr. Smith,
Yes,
I
sir.
warned you. I told your counsel that if you ask me to address bond, I'm going to address the whole thing. So maybe when Ms. Hughes gets done, I haven't made a decision yet, but maybe when Ms. Hughes gets done, this bond goes up. I gave you that warning and you went ahead. So now I'm going to let the people give their version. Go ahead, Ms. Hughes.
Thank you, Your Honor. The people that
To paraphrase Judge Simpson right there, I told you not to fuck around. Now you're about to find out.
are requesting that this court set bond in the amount of $250 cash only. Notably here, the defendant's bond is $50,000 cash only. This is not even a cash surety case, never mind a 10%, which I think is pretty telling given how unique that type of bond is. The defendant is on misdemeanor probation for use of cocaine. It was initially charged as possession of cocaine, and it was pled down to use. At the time of his arraignment in this case, he was already in violation status of his misdemeanor probation. The defendant has a criminal history dating back, as far as I can see, to 2000, which includes a number of drug and alcohol misdemeanor offenses. He also has 6 assaultive felony convictions. In 2014, he was convicted of a couple of cases of R&O on the police.
So I was going to let Miss Hughes go through her whole argument, but gotta stop it there. So my first thought, he's a paranoid schizophrenic, type 1, 2, and 3, and bipolar types 1 and 2. And he's on cocaine. Now, I think drugs, almost all drugs, just need to be legalized and get the violence away from them. I've said it before. You know, if you want to do heroin and you want to be stoned out of your mind 24/7, I'm in favor of like doing. It's almost like the Matrix, frankly. Basically, do heroin centers with. It's like the opium dens back in the day. But basically, if you want to be completely strung out of your mind, give them a bunk bed and put an IV in one arm with heroin and a feeding, nutrition tube in the other arm, and let them be completely out of it. And I figured that's cheaper than the whole incarceration merry-go-round, and it has a cost to society, but it's less than drug gangs and the incarceration industrial complex and crap. I'd never legalize meth because that has too many collateral consequences. It's poison to everyone around it. But I wonder though, at like, if he's in a mania because he's bipolar, if he's in a mania, what's that cocaine doing to him? Or is he trying to get out of a depressive episode? But is he on his medication? Is he trying to use the cocaine to self-medicate? Is it what made him beat a woman's face in? I don't know. But and I'm on the record. I'm quite the bleeding heart. I'm a defense attorney. I don't like people sitting in jail, especially for nonviolent crimes. Even most violent crimes, yeah, you need to be punished for them, but at some point you need a second chance. But at some point you need the key thrown away too. 6 assaultive felonies in the past. Why is he free? Well, why was he free when he beat the woman's face in? That, like, even as a bleeding heart, I think, especially for violent crimes, the punishments need to get steeper and steeper and steeper. And at some point, this guy either needs to be incarcerated for a very, very, very long time, or he needs to be committed to a mental institution for a very, very, very long time. Because he's too violent if he's not. And right as I stopped, it was, he's been violent to law enforcement. He's bad news. But he knows better than Attorney Drukas, Mr. Fake Attorney Drukas.
In 2019, he was convicted of felonious assault and CCW. In this case, this occurred in Miller Manor inside the apartment building, and the apartment building has videos cameras, in the hallway. This case came to the police attention because a neighbor in Miller Manor heard yelling in a hallway. He exited his apartment, went into the hallway, and saw the defendant standing over a woman who had been brutally beat. She was laying on the apartment hallway floor, unable to get away from the defendant. The defendant then fled, went into his apartment. When the police arrived, they first tried to make contact with the defendant. He refused to open the door, refused to provide his name, refused to cooperate with the police. When the police made contact with the victim, her face was so damaged that she could not speak. She could not open her mouth. The police tried to interview her, and she could not even remain conscious. They were able to get.
So, like, he legitimately could be facing attempted murder charges. I don't know if he's facing that or merely aggravated assault, but this is brutal. And a prosecutor Hughes doesn't even know if medically if the victim will be able to go to court, let alone speak in court, because she's got a broken jaw. Now, she's obviously, well, most likely the best witness, but they don't necessarily need her specifically, because if she mentioned a neighbor, I don't remember. Did she just say the neighbor found her after it happened, or if he witnessed part of it? But as she said, it's on video. So if the victim isn't able to speak or go to court, what they can do for the probable cause conference is get the police detective, and they might have to get the property manager, property security, whoever, as custodian of records for the surveillance video to get it introduced, and then just basically authenticate the video to play it, and ask, do you recognize the perpetrator on the video? Yeah, it's Theophilus Smith. He's sitting there in the turtle suit. Do you see him committing a violent act? Yeah, he's kicking the woman's face in. And hey, there's probable cause. So
get her to agree to a medical release. And by the time they presented the medical release to her, she was no longer conscious to be able to sign it. The report indicates that she had injuries to her nose, to her cheeks, and to her jaw. She was immediately rushed to U of M. I am still waiting on her medical records to determine the extent of her injuries. But based on the police report, the police believe that her jaw was in fact broken, which is why her face was swollen and she was unable to speak. Again, Your Honor, our request is $250 cash only.
Mr. Smith sitting there shaking his head. Does he know her jaw wasn't broken? Or was that just it wasn't me, a shaggy shake of the head?
Anything else from the defense?
I think enough has been said, Your Honor. Nothing further.
That was basically Mr. Drukas saying, I told my client to shut up. I don't have anything to add to that. I can't add anything to that. That's why I didn't want to address bond. You moron.
Court believes and the court would find that the setting of the
Sorry to stop so soon, but Mr. Smith is steaming. He's so mad that Mr. Drukas didn't add anything extra. You mean I had to address bond all on my own, even though my attorney told me not to, and now he won't even speak up for me? That's the look on his face. He has steam coming out of his ears. But it's his own stupid fault.
under the circumstances of this case that, and with all due respect to the magistrate, I understand what they were going through at the time, that the bond that is set at that time, court would find that under the circumstances of this case, that may have been an abuse of discretion. The court will increase the defendant's bond in this matter, finding that the defendant is a risk to the public. Well, a clear danger to the public, given the circumstances of what the court has heard. Defendant's bond is increased in the amount of 2,000 or 200,000 cash surety.
Hey, so Judge Simpson gave him a break. He only increased it to 200,000 instead of the 250,000 that the prosecutor asked for. See, he does care about you, Mr. Smith. It is, of course, cash, no 10% option. So, good luck mortgaging the house to get out of jail.
Thank you.
I'll come and see you, Mr. Smith.
Thank you, Your Honor.
You can't see it.
Court calls the case, People versus Raheem Bragg.
You couldn't see it because OSG's end of video stuff came up, but Mr. Smith was muted, but he had words to say to his attorney at the end of the case. And this thumbnail is the sovereign citizen in front of Judge Washington that I mentioned that I might do, just not tonight. So, yeah, that... I realize I had a lot to say on that one, but there was a lot to say because I realize the guy is mentally ill, but that doesn't mean he's stupid. Although his actions in court today would indicate otherwise. So, just a friendly reminder based on this video. Number one, listen to your attorney. They know better than you, at least when it comes to court. And number two, when your attorney says to shut the fuck up, shut the fuck up. And with that, I'm going to shut the fuck up and get out of here. So thanks for joining me. do all the YouTubey stuff, like, share, subscribe, and I will see you soon. Bye-bye.